All right, well, hello everybody, and thank you for joining us on this lovely Wednesday evening. I trust that it's a lovely Wednesday evening wherever everybody is. If it's a rainy Wednesday evening, then apologies for crowing about how it's a lovely evening in Bristol. But thank you very much for joining Michael Selway, who is just sitting to my left, and me to talk about P as claimant and defendant in the civil courts. And as I say, if you could just make sure to keep your devices on mute, that would be helpful. So I am going to start off by talking for 15 or 20 minutes or so about the question of the authority that someone has to litigate from a court of protection perspective. And then I'm going to hand over to Michael, who is going to talk to us about some of the technicalities of the civil procedure rules. And first of all, I'm going to see if the slides are working, which they are. And if anyone's having any difficulty hearing, then perhaps if you use one of your team's emojis to give me a wave or a shout or something, and let me know that that you can't hear us. I've got a green light on the microphone, so I'm hoping that's a positive, and I'm not seeing any gesticulating emojis, so I'm hoping that's a positive as well. All right, so what we're thinking about today is we're thinking about litigating for P in the civil courts, by which I mean for these purposes the courts covered by the civil procedure rules, so High Court and the County Court essentially. And we're thinking from a perspective not just of someone who is a protected party for the purposes of Part 21 of the civil procedure rules, but also thinking with our hats on, thinking about the role of somebody as P within the court of protection and how those two things interface. And really looking from that perspective, where we are if either there is a claim against P or about to be a claim against P, or P appears to have a claim. And I'm not talking here, of course, about the sort of litigation that goes on internally within the court of protection. So I'm not talking about health and welfare or property and financial affairs applications and disputes within the court of protection. I'm thinking very much about litigation in the civil courts, which could be anything. So it could be any sort of claim that P might have or might face, just like anybody else, of course. Now, when this situation comes up, it seems to me that P is essentially going to have one of three different situations. P might have a deputy that's already been appointed by the court's protection. P might have an attorney under a lasting power of attorney, or conceivably still under an enduring power of attorney, or P might have neither. And to start off with, there are really, I would suggest, two questions in play, and it's important to distinguish between what we're thinking about and essentially between the point that I'm going to talk about briefly and the point to which Michael's going to come on. The first is the question of authority to conduct litigation on P's behalf. Ordinarily, of course, you can have authority given to you by a capacitous person. Of course, if P doesn't have capacity, P can authorize some things through, pre-authorize some things through a lasting power of attorney when P did have capacity, or of course the court of protection itself has the power to authorize things. And that's one question. Does someone have authority in that sense, essentially in the sense as between P and the person who's acting on their behalf? And the second question is, does someone have power to litigate for P under the civil procedure rules? And those two things are different questions, because of course, if you get into the civil procedure rules, as Michael is going to do shortly, you will see that there is a framework for the civil court dealing with someone lacking capacity, and a framework for putting someone in the position of being able to litigate on their behalf. So the power to litigate exists independent of any question of whether someone has authority from the Court of Protection or otherwise, because the question the civil court will ask is a litigation friend required? Do you have a protected party who needs a litigation friend? And if so, is there someone who is becoming that litigation friend either without a court order or with a court order? And that is a different question to the question of whether someone has authority. In a sense, for those of us who do chancery work, it might be a bit like thinking in terms of the position with a trustee or something like that, where on the one hand, they might be perfectly capable of pursuing litigation on behalf of the trust, but then there might also be an underlying question as to whether they were in a position to ensure that they were protected from their own potential exposure and potential exposure as against the trust, in fact, in so doing. So I'm turning first to the question of authority, and a useful observation, as is often the case, it seems in courts of protection, one gets various cases bundled together for judicial assessment of what the underlying position is. And in the case of re-ACC, JDJ, and HPP, which was a 2020 Court of Protection decision of Her Honour Judge Hilda, whose name will, of course, be incredibly familiar to those who practice in the Court of Protection, this case dealt with the question of the authority of deputies. And at the outset, it's useful to reference what Her Honour Judge Hilda said at paragraph 51.1 of that case. The effect of the Court of Protection authorising a deputy to conduct proceedings on behalf of P is twofold. Firstly, it gives the deputy priority over others in the hierarchy of potential litigation friends for P. And secondly, it enables the deputy to use P's funds to meet the reasonable costs of the litigation and to pay a costs order made against him in the proceedings. And we'll see that at no point within that passage, which is just to reiterate what I've just said, does Her Honour Judge Hilda say the effect of the Court of Protection authorising a deputy to conduct proceedings is to empower them for CPR purposes to carry out those proceedings. Again, we're looking at something separate. So it's a question of what their standing will be when it comes to the CPR test for becoming a litigation friend. And it's a question of their own protection in costs, in terms of costs that they might run up, and indeed cost orders that they might run up if things unfortunately take a bad turn. Now, thinking first and primarily about the position of deputies, the power to appoint a deputy arises under the Mental Capacity Act 2005, Section 16. And that power in respect of property and affairs is discussed further in Section 18. And it extends under Section 18(1)(k) to the conduct of legal proceedings in P's name or on P's behalf. And it's important to emphasize, and this is a point that arises very clearly from Her Honour Judge Hilda's decision, this doesn't equate to automatic litigation friend status, but does give priority under CPR Rule 21.42. Well, that's not even, in fact, really something that Her Honour Judge Hilda had to make clear from that case. That's just how the CPR operates. We've seen her reference to taking priority, but because they are different, getting that authority and becoming a litigation friend are separate steps. But also, very importantly, the fact that the power extends, and this is the point that Her Honour Judge Hilda was really primarily dealing with in that case, the fact that power extends to authorising litigation does not mean that the authority granted will, in fact, extend that far. So this is the jumping off point for the consideration that the judge gave to various questions in the case. Paragraph 51.3, general authority does not extend to conducting litigation. So if there is a standard form general authority to a deputy, that is not enough to represent authorization from the Court of Protection to conduct litigation. And having dealt with that, well, Judge Hilda makes this observation about effectively the fact that the court may want to keep a closer oversight on things than just allowing someone with general authority to go off and litigate. So paragraph 51.4, when the court considers an application for authority to conduct proceedings, it will consider whether there should be limits to such authority. If there are concerns as to merits or costs or otherwise, the authority may be, and often is, granted only up to a specified stage of proceedings, when another merits assessment may be required, or with a limit on the costs which may be incurred without further application. And again, those who practice in the chancery field may recognise the sort of concern that's being voiced there as the sort of concern that might be in play if someone was making a Bedo application and asking the civil courts to authorise litigation. So then Her Honour Judge Hilda had to consider some specific questions about the general authority and how far it does in fact go. My summary, of course, I would suggest if you've got a particular knotty question about a particular scenario, it's worth looking into the judgment, because this is a bullet point summary of some of the points that on my reading of it leads to. Ordinary non-litigation legal tasks ancillary to what is authorised, that would appear to be within the scope of the general authority, as might some advice on some contentious litigation. And what do we mean by some advice on some contentious litigation? Well, where potential litigation is about property and affairs, and a concept that the judge adverts to is effectively the idea that of thinking, is what you're taking advice on something that you'll be able to do once you've taken that advice under the authority that you have. Where potential litigation is about property and affairs, general authority extends to some advice and counsel's opinion on the merits, and as far as the letter of response. So if you are in the territory of dealing with some potential litigation that concerns the matters over which a property and affairs general authority would extend, on the back of that judgment, it would appear to be the case that taking advice on the merits and engaging in a pre-action exchange of letters ought to be covered by the scope of that general authority. If you are outside of property and affairs, so if whatever the potential litigation is about is really not within the wheelhouse of the deputy, given what they've been authorised to do as a property and affairs deputy, and we're thinking here about a deputy with a general property and affairs authorisation, then the general authority would only actually extend as far as drawing the court's attention to the situation by seeking directions, rather than seeking to actually pursue the steps towards litigation further. And one can see why that might be, that actually why getting legal advice and exchanging correspondence about something that's not actually within the scope of a property and affairs deputyship anyway, why that might be seen as going too far rather sooner than preparatory actions in respect of property and affairs matters might be. And that then leaves the question also of urgency. What if, in the particular proposed litigation, some protective step needs to be taken quickly to look out for P's interests? Well, that can be approved retrospectively, but Her Honour Judge Hilda makes clear that you are looking at dealing with that on a case-by-case basis. So the general suggestion would be, I think, arising from that if you think you need to do something that's not within the scope of the general authorization quickly to protect P, firstly, be clear that you do need to act more quickly than you're able to get in an application to the court. And once you've taken that litigation step that is urgent, get to the court quickly and don't just go barreling off with the rest of the litigation, explaining this is the urgent step that we've had to take. Can we have authorization for it? And can we have some directions before any less urgent further steps are taken? That would appear to be the tenor of the point arising from that judgment. Now, turning to attorneys is where actually the situation becomes slightly more interesting than I thought it would be, in the sense that it's one of those situations where I was expecting, when I looked at it, to find a clear answer. And the answer that I found wasn't quite as clear as I'd anticipated, in that there is a case called Gregory and Turner, which you will see, at least in one practitioner text, you will see referenced with reference to the idea of the fact that an attorney doesn't have authority to conduct litigation. When you actually look at, so I had, you can see discussion of that, for example, of that case, for example, in Hayward and Massey. When you actually look into the ratio of the case, it's an interesting case, and it concerns the sort of point that the council might find interesting, which is the extent to which someone can be authorized as an attorney to conduct litigation in court and to exercise a right of audience. But effectively, it's dealing with the question of whether a litigant in person's ability on their own behalf to conduct their own litigation and to be a litigation and to appear in court on their own behalf can be handed over by way of agency or attorneyship to somebody else, which means potentially the ratio of the case is not straightforwardly on point for the question of whether or not an attorney could be treated as having, as it were, pre-authorization by P. Interestingly, I haven't been able, as I say, the suggestions that I've seen point to the idea that one wouldn't have confidence in that. And my own position would be that it's not obvious to me that one could confidently proceed as an attorney on the basis that one had a pre-authorization to indemnify oneself from P's funds in pursuing litigation. But as I say, the question wasn't as clear-cut for me to find the answer to as I expected it would be. And it would be interesting, in fact, if anyone on the webinar has their own view as to what the answer to that is and wants to let us know afterwards, I would be really interested to hear that. Although if it was me, I would be very cautious about an attorney pushing ahead on the basis of being an attorney in seeking to become a litigation friend without more, and assuming that they had an indemnity in so doing. And then perhaps, to state the obvious, if you've got someone who's not a deputy and who isn't an attorney, then obviously they don't have any sort of special authorization to conduct litigation and have no special protection if they go on to become a litigation friend. So finally, before I hand over to Michael, I'm just going to briefly touch on this question of becoming a litigation friend before Michael goes into it in some more detail, just thinking about Rule 21.4. And this is just touching on that point that Her Honour Judge Hilda makes about the fact that about effectively getting some priority in becoming a litigation friend. But as I say, it doesn't mean one automatically does, because under Rule 21.4, one of the people who can become a litigation friend without a court order is a deputy appointed by the Court of Protection under the 2005 Act with power to conduct proceedings on the protected party's behalf, is entitled to be the protected party's litigation friend in any proceedings to which the deputy's power extends. It's worth noting that is disapplied if someone has already been appointed by the court under Rule 21.41. It's also worth noting that an attorney under an LPA has no such special entitlement, but you'll see that a deputy is able to get themselves, as it were, further forward in the queue in seeking to be a litigation friend. And with that, I'm going to, and with an attempt to pan the camera, which of course goes in the wrong direction, there we go, I'm going to hand over to Michael to talk a bit more about the CPR. Michael.
Thank you, Oliver. Yes, as Oliver says, I am going to talk a little more about the general application of, in particular, Part 21 of the Civil Procedure Rules, but also some other provisions of the CPR that are applicable where a civil litigant lacks capacity to conduct proceedings. My slides are going to use the structure of Part 21, and some of this will undoubtedly be familiar to you, but hopefully some of it will be new and of interest. Starting with, in an appropriate place, I think, with 21.1, which provides generally, of course, that Part 21 applies in proceedings involving protected parties, in addition to the other rules of the CPR as modified when dealing with a party who lacks capacity. Protected parties, for the purposes of Part 21, are defined as a party or an intended party who lacks capacity to conduct the proceedings within the meaning of the Mental Capacity Act 2005. And a few points to draw out of that are, firstly, that the reference to an intended party gives these rules some scope and application prior to the actual commencement of proceedings. The rules in Part 21 apply to claimants and to defendants. In some places they make clear that they apply to one or the other, but in general, Part 21 applies to claimants and or to defendants. And indeed, the rules in Part 21 apply in a similar way to additional claims, such as counterclaims. The definition that I referred to refers to capacity to conduct proceedings within the 2005 Act. Again, a couple of points to draw out of that. Conducting proceedings is an example of the application of the 2005 Act and Part 21 in relation to specific capacity issues. So here's specifically the capacity to conduct the proceedings in issue. That's the question that the court has to deal with. Having said that, it is looking at the whole proceedings, so that if a party has capacity to conduct part of a set of proceedings, they don't have capacity to conduct proceedings for the purposes of of Part 21. It's a binary question. Do they or don't they have capacity to conduct the whole proceedings? And reference to the 2005 Act requires consideration of especially sections 1 to 3 of that Act, including, for instance, that a person is assumed to have capacity unless it's established that they lack it, and that capacity is a person lacks capacity if they are unable to make a decision for themselves because of an impairment or a disturbance in the functioning of the mind or brain. The issue of capacity in civil litigation can be raised by any party or indeed by the court of its own motion, and a court should do so, should raise that issue at the first convenient opportunity if it has any doubt about the capacity question. And if there is doubt about capacity, then the court is likely to want expert evidence to answer that question, usually medical evidence and indeed potentially usually specialist medical evidence and further current medical evidence. There is a court form, a useful court form in my view, called the Certificate of Capacity to Conduct Proceedings, which provides space for such an expert to answer the relevant questions that the court will want to know the answers to. However, and having said that, it is ultimately a court decision as to whether a person on the balance of probabilities has or does not have the relevant capacity to conduct proceedings. I've also referenced on the slide the definition of protected beneficiary, which appears in Rule 21.1. I'll come on to that later, but a protected beneficiary is a subset of protected parties, i.e. people who lack capacity to conduct proceedings, that subset being people who also lack capacity to manage and control any money recovered by them or on their behalf or for their benefit in the proceedings. 21.2 contains the key provision that a protected party must have a litigation friend to conduct proceedings on their behalf. A litigation friend has a duty to take all measures that they see fit for the benefit of the protected party to safeguard their interests for the purposes of the litigation, and to do so under proper legal advice if and as appropriate. There is no broader duty on a litigation friend as such to act in the party's best interests more widely. But of course, if the litigation friend is also an attorney or deputy, then they will have that duty as part of that capacity, as part of that role. I've also referred on the slide to the correct title to proceedings where a person is a protected party represented or acting by a litigation friend. Rule 21.3, and I've taken the majority of that rule for the purposes of the slide, because again, this is a key provision in my view, sets out the consequences of the litigation friend requirement. And one can see that that requirement has consequences, both where there's a lack of capacity at the issue of a claim, and even before, or where that lack of capacity occurs or arises during proceedings. In general, no step in proceedings can be taken until a litigation friend has been appointed to represent a protected party, and no pre-action application can be made against the protected party. And any step taken before a litigation friend has been appointed has no effect. It's tolerably clear that the court can make some orders and directions, for instance, in trying to get to a determination about whether a party has or does not have capacity. But orders made by the court are at risk of being set aside if made before a litigation friend it has been appointed where a party lacks capacity, especially if they have some substantive effect or something of that nature. The exception to the general rule is that a party can issue and serve a claim form and apply for the appointment of a litigation friend if necessary before a litigation friend has been appointed. That's in the case where the protected party who needs the litigation friend is the defendant. It seems tolerably clear extend to where a claimant lacks capacity, they are going to need a litigation friend from the start. The court does have, as set out in the slide, power to give prospective permission to a party to take a step without a litigation friend, without a protected party having a litigation friend, or to grant retrospective validation where a step has been taken, where a protected party is involved before they have a litigation friend. And it has been said in the case law that provided everyone has acted in good faith and there has been no manifest disadvantage to a party who lacked capacity at the relevant time, then the court may be willing to retrospectively validate orders that have been made. However, everything must depend on the particular facts of the case, and it has been said that the court may be prepared to validate some steps and not others. In Dunhill and Bergin, the Supreme Court would not validate a final settlement that had been reached where a party was found subsequently to lack capacity and had not had either a litigation friend or the settlement approved by the court, which is a provision that I'll come on to. These consequences, this requirement for a litigation friend, can be a real difficulty. It can bring proceedings to a standstill if a litigation friend cannot be found, and it can be a really difficult question in a particular case as to how to deal with that and move in order to move forward. The official solicitor may act as litigation friend where no one else is able or willing to do so, but first requires that their liability for costs be covered and may not be a viable option in many cases. Rule 21.4 refers to the appointment of a litigation friend. There's two ways to have a litigation friend appointed, either with a court appointment or without a court appointment. Court appointment is given ultimate primacy. If a person has been appointed by the court, then the option to do it without the court no longer remains. So this rule, which deals with appointment without a court appointment, is subject to the proviso that if it applies if a court has not appointed a person to be the litigation friend. If that is the case, then this rule sets out the qualification to fulfill that role. and as Oliver said, gives primacy to a deputy who has it within their power to conduct proceedings. A deputy with power to conduct proceedings on behalf of a protected party is entitled to be their litigation friend. As Oliver said, again, it doesn't apply to an attorney. An attorney is in the same position as any other person, but if there is no deputy, then any other person can be appointed as litigation friend if they fulfill three criteria, in addition to consenting to act as litigation friend. Those criteria, as set out on the slide: firstly, that they can fairly and competently conduct proceedings; secondly, that they have no adverse interest to the protected party, which, as an aside, doesn't mean that that party that a person cannot be a litigation friend only if they have no interest in the outcome of the case. They may have an interest in the outcome of the case, but if it's not adverse to that of the protected party and doesn't affect their ability to fairly and competently conduct proceedings, they can still be appointed as a litigation friend. The third requirement is that is applicable to where the protected party is the claimant. The litigation friend in that respect must undertake to pay any costs that the claimant protected party may be ordered to pay, subject to their right, or any right they have, I should say, to be repaid from the protected party's assets. A defendant's litigation friend can, in some cases, be ordered to pay the costs that a defendant protected party would otherwise have to pay to the other side, but that is probably only where they have breached the conditions imposed on them to conduct proceedings competently and fairly, and so on. Otherwise, it wouldn't be the norm. Rule 21.5 follows on from 21.4. This is how a person becomes a litigation friend in the absence of a court appointment and without a court appointment. A deputy, if they're to become the litigation friend, must file an official copy of the Court of Protection order conferring their power to act as deputy and with authority to conduct proceedings. Any other person has to file a certificate of suitability stating that they satisfy the conditions referred to in Rule 21.4, that's fairly and competently conducting proceedings and so on. And crucially, on behalf of a claimant, the documents that I've just mentioned have to be filed when the claim is made. On behalf of a defendant, those documents have to be filed when either the deputy or other person who's to become the litigation friend first takes a step in the proceedings on behalf of the defendant. If those documents aren't filed at those times, it seems that they cannot be done. They cannot be filed later with the effect that a person becomes a litigation friend. So if a proposed litigation friend for a claimant doesn't, for instance, file their certificate of suitability when the claim is made, they may have to rely, or it seems they will have to rely on having a court being appointed by the court, not being able to rely on that power of appointment without the court's involvement. The certificate of suitability referred to on the previous slide must be in the prescribed form N235, verified by a statement of truth, and state that, firstly, the litigation friend, the proposed litigation friend, agrees to act. It's clearly a requirement. Secondly, that the proposed litigation friend knows or believes that the party in question lacks capacity to conduct the proceedings, and state their grounds for that knowledge or belief. And thirdly, must be stated that they meet the conditions in Rule 21.4, being able to conduct the proceedings competently and fairly, and so on. The litigation friend, as well as filing that certificate of service, must also serve the certificate of suitability, I should say, must also serve it in accordance with CPR Rule 6.13, which I'll come on to, and a copy of any expert opinion on capacity, and must file a certificate of service when filing the certificate of suitability. Rule 6.13 before I move on to the next slide. And Rule 6.25 Rule 6.13 is referred to in Rule 21.5, but in fact, both of those rules, 6.13 and 6.25, are important standalone provisions for litigation, which can be overlooked. Certainly, I've had a case recently where they were overlooked, and that can have potentially serious consequences. 6.13 on service provides that where the defendant is a protected party, the claim form must be served on their authorised attorney or deputy, or if none, on an adult who they reside with or whose care they are in, subject to the court making an alternative order, either prospectively or retrospectively. If the claim form isn't served in accordance with that provision, then it hasn't properly been served. And unless the court is prepared to grant an order, a retrospective alternative order, the claim hasn't properly been served, with the consequences that follow from that. 6.25, I should say 6.13 is the rule that is referred to in Rule 21.5 in relation to the serving of the certificate of suitability. Other than where specifically provided, Rule 6.25 deals with documents other than the claim form, and that provides that any other document must be served on the litigation friend conducting the proceedings on behalf of the protected party, subject again to the court making an alternative order. But in 21.5 and elsewhere in Part 21, the service required is in accordance with Rule 6.13, which generally refers only to claim forms, but here refers to other documents as well. Rule 21.6, taken together with Rule 21.8, deals with the alternative possibility I mentioned of an appointment of a litigation friend by court order. For these purposes, an application for that order may be made by a person who wishes to be a litigation friend or by a party to the proceedings, and in some circumstances for a claimant must be made, those circumstances being where the claimant has brought the claim against a protected party who doesn't have a litigation friend, and either a defence is filed by somebody else on their behalf, or the claimant wishes to take a step in the proceedings. They must make this application for the appointment of a litigation friend. Such application again must be served in accordance with Rule 6.13, and unless the court directs otherwise, must also be served on the protected party. Thought should also probably be given to whether the other party to the litigation should be served with a copy of that application in a particular case, even though a provision isn't actually made for it. Query whether, as I say, in a particular case, they should also be served. Such application must also be supported by evidence of the Rule 21.4 conditions being satisfied, and the court must be satisfied that those conditions are met by any person that it then appoints to be the litigation friend. Noting, as an aside again, that the court may appoint the person proposed in the application or any other person who satisfies those conditions. So it may be that the court doesn't wish to appoint the person proposed, but someone else meets the conditions and can be appointed. And the court may act of its own motion in making such appointment. Normally, it should be done by application and supported by the evidence, but it does appear that the court can act of its own motion. Presumably, it will need to have the evidence from somewhere, but it can be the moving party in this regard. And I note at the bottom that because it's noted in these rules, that the official solicitor, as I mentioned earlier, may be appointed as litigation friend as a sort of a last resort. But if they are, then any order appointing them must provide for payment of their charges, expenses, or disbursements. A couple of rules which I'll deal with more quickly. Rule 21.7, allied with Rule 21.8, the court may direct that a person may not act as a litigation friend, or terminate an appointment, or appoint a replacement litigation friend. And there are rules in 21.7 and 21.8 about making such applications and about service of such applications. And this applies whether the original litigation friend to whom either their appointment is being terminated or a replacement is being appointed or so on, whether they were appointed by the court or outside without a court order. This rule applies. Rule 21.9, where a protected party regains or acquires capacity to conduct proceedings, the litigation friend's appointment will continue until it is ended by court order. And again, that rule provides further provision as to making an application for such an order and for giving notice of relevant matters to other persons. And again, that rule applies however a litigation friend has been appointed, but with or without a court order. 21.10 is another very important, I mean, they're all important provisions, I suppose, but this is a particularly important provision. This provides no settlement, compromise, or payment, and no acceptance of money paid into court shall be valid so far as it relates to the claim on behalf of or against the protected party without the approval of the court. This includes, it seems, a Gruyere agreement is reached under Part 36. It includes if there's a partial settlement of the claim, and it can include where a claim is discontinued if that amounts to or is part of a settlement. It wouldn't ordinarily apply to discontinuance, but if it's part of a settlement, then this rule 21.10 can apply. It applies both where proceedings are reached, settlement is reached before proceedings are begun, and where it's reached during proceedings. Where agreement is reached before proceedings are begun, there will need to be a claim for the purposes of obtaining court approval of that settlement. Where there are proceedings on foot, an application for court approval will need to be made, and in either case, the claim or the application will need to be supported by certain documents that are specified in 21.10 and otherwise made in accordance with that rule. Consent order should normally be made in the court form N292 or similar, and in any event, a litigation friend will be needed if there isn't already one appointed. For example, if proceedings aren't on foot but need to be made for approval of the settlement, a litigation friend will be needed. In the case that I mentioned earlier, Dunhill and Bergin in the Supreme Court, that was a case in which proceedings were settled and a consent order was made by the court, but the Supreme Court held that the embodiment of that settlement in the consent order did not constitute approval of the court pursuant to Rule 21.10. And that was even where, at the time that the settlement was reached and the consent order made, none of the parties or their advisors were aware that one of the parties to that settlement was in fact a protected party who lacked capacity to conduct the proceedings. And because the approval of the court hadn't been obtained, and in fact because a litigation friend hadn't been appointed, that invalidated the settlement, and the consent order was set aside. So it's very serious consequences. Partly for that reason, I think it has also been held that the court has an inherent jurisdiction to approve settlements of claims, and that if it does so, if it approves the settlement of a claim, that approval is sufficient to satisfy the requirements of Rule 21.10, even if at the time it's sort of just being done as a precautionary measure, where it hasn't been even raised, let alone found, that a person lacks capacity, but just in case they do, the parties seek the court's approval. That has been held to be possible and was applied in the case in a particular case. I'm not sure that it would be applied in every case. I would query that, but it certainly is possible and is something that is worth considering. If there might be some doubt about capacity, I think it can potentially avoid the problems that were encountered in Dunhill and Bergin, and therefore is certainly worth a consideration. Two more slides to go through. Firstly, dealing with two provisions together here, 21.11 and 21.12. These deal with the position that where in proceedings money is recovered or money that has been paid into court is accepted by or on behalf of or for the benefit of a protected party. If so, it will be dealt with in accordance with Rule 21.11 and directions given by the court under that rule. In dealing with this, the court will consider whether the protected party, who lacks capacity to litigate, is also a protected beneficiary. And that's the definition that I referred to earlier of someone who also lacks capacity to control and manage the money they're receiving. If that is the case, if they are a protected beneficiary, then if the money recovered is £100,000 or more, where there is no relevant attorney or deputy to deal with it, the litigation friend will have to apply to the Court of Protection for the appointment of a deputy, and the money must then be dealt with in accordance with the orders of the Court of Protection. If and or when a deputy or attorney has been appointed, then it may well be that the money is dealt with them in accordance with such powers as they have in those roles, although they may need the assistance of the Court of Protection if those powers don't go far enough, and or to check what they are doing. The rule here about protected beneficiaries, interestingly, and perhaps this is a gap in the rules, does not deal with the situation where somebody has capacity to litigate, but not capacity to manage and control money recovered in litigation, because Part 21 deals with protected parties, which are people who lack capacity to litigate, and protected beneficiaries are a subset of those people. So by definition, they must lack capacity to litigate. But of course, some people may have capacity to litigate, but not have that capacity to manage or control the money received. If that is the case, then certainly I've seen it suggested that there may need to be an application to the Court of Protection for the appointment of a deputy in advance of monies being paid out, so that that deputy can deal with the monies with any further assistance required from the Court of Protection. Conversely, where judgment is entered against a protected party, then further steps may well be required for the enforcement of that judgment. For instance, any deputy may have to apply to the Court of Authority for any necessary authority to pay a judgment sum out of the protected party's funds. And finally, on for this slide, a litigation friend who incurs costs or expenses in proceedings on behalf of a protected party is entitled to apply to the court for reimbursement of those monies out of the monies recovered or paid into court. And there are court forms that are relevant to this stage of any litigation in terms of settlements or judgments and management of funds. Finally, a few other rules that apply throughout this from the CPR, not as Part 21, that apply to parties who lack capacity to litigate. Firstly, Rule 46.4 and Practice Direction 46, paragraph 2.1, they provide together that where in any proceedings money is ordered or agreed to be paid to or for the benefit of a protected party, or ordered to be paid by or on behalf of that protected party, then the general rule, subject to a number of exceptions, is that the court will order a detailed assessment of the costs payable by or out of money belonging to the protected party, and then also any costs payable to them. And this relates to inter partes costs and party solicitor costs. There are circumstances in which a detailed assessment need not be ordered, including where costs have been agreed on behalf of a protected party and any further claim to costs has been waived, and provision is made for where there is an applicable fixed cost regime, and there are other circumstances, but that is the general rule to which parties should and don't always have regard when in particular, actually, when reaching a settlement, but also when the court comes to deal with the costs of a set of proceedings. And there's also some other rules there that I've mentioned just briefly in passing, parts 12, 22, 39, which are applicable to parties, or can be applicable to parties who lack capacity to litigate, and again, should be have regard to if one finds themselves in the position of dealing with a client or against another party who lacks capacity to litigate. And that is, I think, my time. So I will hand back to Oliver.
Thank you very much, Michael. I'll stop sharing if I can. Can I stop sharing? Yes, I can. There we go. Well, thank you, Michael, for that. I don't know whether I'm very conscious of the fact that we're 5 or so minutes away from 6 p.m. and as I've alluded to, it's a lovely evening out there for at least those of us who are local to Bristol. So I won't at this juncture invite an extensive discussion, but if anyone had any observations or points they wanted to flag in the chat, then feel free to do that. But failing that, thank you very much for joining us this evening. I think it's an interesting area where the Court of Protection merges in with civil procedure, and my own perception is, for what it's worth, is that the provisions of Part 21 have a lot of detail, but actually sometimes they don't necessarily always have the tools within them to actually get parties who are caught up in a difficult situation around capacity the answers that they necessarily need. Michael, I don't know if you would share my perception that sometimes the area is quite rule heavy, but it's not necessarily answer heavy.
I certainly, if the point is that there are some, as you say, despite the quite dense rules, there are some gaps in them which don't cover all situations, I would agree with that.
And so it is interesting, I think, trying to look from both sides of the, as it were, of the fence, looking from often people in the sphere of civil litigation are looking at a capacity issue as an issue that's arising and complicating a case that they might think is a debt claim or a possession claim or whatever it might be. But at the same time, people looking from a court of protection perspective maybe seeing potential litigation in the civil sphere as something that's complicating the world of dealing with P's property and affairs. So anyway, thank you very much, everybody, for joining us this evening, and I hope you found that of some interest, and do of course look out for any further webinars, seminars, that sort of thing that that Chambers has to offer, I hope. And thank you very much, and I hope everybody has a good evening.